They also say that they want Pittman to consider their motion for a preliminary injunction first before he considers the venue. He says, no, I'm not doing that. I'm a judge. I know how I'm going to handle my cases, and I'm concerned about venue. So
can I just interrupt you? That's appropriate, right? Completely appropriate, because venue is a threshold issue.
It's not only appropriate, as we will find out later, it's what the Fifth Circuit has told judges to do.
Welcome to Law and Chaos. Today, we'll be discussing the ongoing disaster in the Fifth Circuit with Chris Geidner, a reporter who's been covering the federal courts for 2 decades. We'll get deep in the weeds on 2 recent cases where the appeals court has actually clawed cases back from other jurisdictions to ensure that it can leave its crazy mark on America's laws. And spoiler alert, these judges are not in the business of making government function better for average Americans. We've got a lot to cover, so let's get after it. Hey guys, I'm Liz Dye, and today we're going to do a deep dive into a couple of cases out of the Fifth Circuit. But first, in happier news, Donald Trump's efforts to put off his criminal trial in New York appear to be hitting a big old brick wall. I wrote about it a bit in Wednesday's Post, and Monday's show will be all Trump again. But briefly, Trump's lawyers have filed a bunch of last-ditch garbage motions, hoping to get an appellate judge to stay the proceedings. And as of this recording, not a single one of them has worked. On Monday, Trump, who has spewed an absolute fountain of abuse at everyone involved in this false business records case, demanded that it be moved out of New York because of prejudicial pretrial publicity. See, Michael Cohen and Stormy Daniels said mean stuff about him on Twitter, and that is no fair. That motion failed, no surprise, so the next day his lawyers were back with a different motion whining that Trump can't go to trial because he needs the gag order lifted so he could abuse the witnesses online, specifically Cohen and Daniels. That one also got shot down. Unsurprisingly, the appellate judge was not super impressed with the argument that Trump needs to shit-talk witnesses to get a fair trial. And then on Wednesday, his lawyers were back with the weirdest motion yet. Here's what they argued in that one. I'm reading. It's, look, these are like one-line briefs. This is the entire thing. They said, the unconstitutional effects of Justice Merchan's ruling are causing ongoing, irreparable constitutional harms to petitioner and the voting public, and if not stopped, will prevent petitioner from receiving a fair trial. Those are all words. I do not know what the hell they mean when rendered in that order, and I'm not sure how Trump thinks he's in a position to vindicate the rights of the voting public to, not see him go to trial. I think his theory here has been that it's election interference to keep him in court and off the campaign trail, which, whatever. His lawyers argued all of that in court. They filed another motion for Merchan to recuse, and he hasn't ruled, and that's a due process violation. That's what they said. And they complained that Justice Merchan made him stop spamming the docket with stupid motions on the eve of the trial, and they said that's a due process violation. And they said it's not fair to make him stand trial in Manhattan because everyone there voted for Hillary, and that's not a due process violation. But, it's fun to say crazy shit. Anyway, none of that worked. Boo-hoo, too bad, so sad. So that motion was rejected, and now we're going to see whatever they've got left in the barrel. So this is going to be some crazy, desperate shit. Probably about the time this show drops, there'll be something crazy that happens. He'll plead that someone close to him is ill and he simply can't be in court, or one of his lawyers will say that. He tried this in January when Melania's mother died during the E. Jean Carroll trial. It didn't work, but, I guess that means he can't use that particular excuse again. Maybe Kimberly Guilfoyle, Don Jr.'s girlfriend, is about to have a tragic Botox incident, or Eric Trump will think hard and get a migraine, or Melania will smile and her face will crack. I don't know, but one of the last refuges is always, claiming that someone associated with this case is ill and the trial has to be postponed. So everything else has failed. I would expect to see that. At any rate, it's going to be wild. And there's already news on Twitter that CNN has some crazy breaking news. I shudder to think. Okay, we are going to get to the show in just a second. If you are a subscriber at patreon.com/lawandchaospod or on Substack at lawandchaospod.com, you get the ad-free version every time. And there will be a longer version of the show for you But if not, we will see you in just a second after we pay some bills. And with us today is Chris Geidner. He's a legal journalist who covers the federal judiciary, particularly the Supreme Court. He's reported for decades on LGBTQ rights, and his Law Dork column is essential reading for everyone who cares about what's happening in an era where conservative judges have seized control and decided to cancel any laws they personally dislike. Chris, thank you so much for being here.
Thanks a lot, Liz.
All right, so let's get into it. What is the matter with the Fifth Circuit?
What is not the matter with the Fifth Circuit?
True.
The Fifth Circuit is one of the most conservative courts that we have in the nation, and that's in a nation where we have the U.S. Supreme Court. So that's saying something. Yeah. And one of I always like to bring people into understanding what is going on at the Fifth Circuit by explaining that there are more Trump appointees on the Fifth Circuit. There are 6, than there are Democratic appointees altogether. There are only 5, and that's only because Biden has now gotten 2 nominees confirmed to the Fifth Circuit. So we're talking about a 17-person court that only has 5 Democratic appointees, and it's not just that. There are other courts that are lopsided like that, but it's the fact that there are so many Trump appointees on this court that are so extreme. Many of them are young. Many of them think that they deserve a Supreme Court seat and are acting accordingly. And the result of that is a few things. We get some very extreme decisions out of the court that even are too extreme for this U.S. Supreme Court. But we also are getting a situation where district court judges within the Fifth Circuit feel so empowered by the extremism of the Fifth Circuit that they think that they can get away with anything. And we've seen that particularly with like Matt Kaczmarek in the Mifepristone case. We saw it from a district judge in Louisiana with this case that the Supreme Court just heard over the Biden administration's attempt to stop disinformation, discourage disinformation relating to COVID and elections. And the sort of weird dynamic that I've talked about is that it's kind of an opportunity for the Supreme Court at times, because it gives the conservative Supreme Court the opportunity to push back at some of this, to look moderate, while also letting some things go through that just wouldn't from other courts or in other eras. And so they sort of, they get the best of both worlds by having this very extreme outlier court.
Yeah, I would agree with you. I mean, you talked about the Mifepristone case, and we've talked about that a bunch on the show. That was Judge Matthew Kaczmarek basically said, I'm going to go back 23 years and undo the FDA certification of this drug. And then the Fifth Circuit said, oh, you know what? We'll just make it a little, 3 ticks less crazy and only go back 6 years because of the statute of limitations. And now it's at the Supreme Court, which is, I think, pretty likely to kick it on standing.
Yeah. And we saw basically the same thing with the social media case, because Doughty's injunction was absurd. This wild prior restraint against communications, many of which were constitutional and clearly protected speech. In the administration's, thousands of people in the administration's interactions with any social media companies. The Fifth Circuit then still found standing, still allowed for this injunction, still found that the Biden administration had essentially converted these social media companies into state action. But then they gave a narrow injunction. And so they pretended like this was a much more narrow decision. But then when it got up to the Supreme Court, they were like, what? what do you mean?
Right.
How
Right.
would that work in practice going forward, let alone in this case? And it's just this recurring scenario that it is really, it's one of those, like, is it a bug or is it a feature? Like, yeah, the Supreme Court can act all indignant and reverse the Fifth Circuit a bunch, but if you're letting 20% of extreme decisions that are moving the law to the right to go through, are they really correcting the Fifth Circuit, or are they allowing sort of the mass extremism of the Fifth Circuit to allow minor extremism to still happen?
Right. And I really don't appreciate being forced to like root for Justice Brett Kavanaugh. Like Justice Brett Kavanaugh in both of these cases that you just referred to was like, what the hell are we even doing here? And was pretty reasonable. He had a pretty strong First Amendment stance in the net choice cases. We discussed that on the show with Corbin Barthold. And in the Mifa Pristone cases, he seemed basically like, oh, come on, standing is for real. Standing is an actual thing, even though Justice Alito was like, well, if nobody has standing, then that's not a thing. Somebody must have standing. And like that's not been Alito's position historically.
Well, that's not been the conservatives' position writ large for the past 40 years.
They are not in the business of throwing open the courthouse doors to all comers. But okay, so the Fifth Circuit problem is twofold, right? Because it's a problem at the Fifth Circuit, but it's a problem at the district court level too, not just because they feel emboldened, but because of some like not trickery, but not trickery on the part of Mitch McConnell, right? He did some very specific things to allow the Fifth Circuit and Texas specifically to be a place where these things get started, these crazy cases get started.
I mean, the Northern District of Texas has this procedures that it has devised for how it is going to assign cases. It's split into these divisions, and there are single judge divisions that, in essence, you'd need to look at Steve Vladek's charts for what's what. But essentially, a lot of cases end up going, if they're filed in certain divisions, to one judge 80%, 90%, or 100% of the time. And because of that, you have things like we saw in the Mifa-Pristone case, where you literally form an organization that happens to be located in the Northern District of Texas, and then you file in Matt Kaczmarek's division and know that he's going to get the case. And know
that's Amarillo, Texas. He's the only game in town, and once in a while, if you file in Amarillo, you won't get him, but most of the time, if you file in Amarillo, you'll get him, and you'll know that he's crazy. He was a lawyer for a religious conservative, legal action group before he became a judge. Let's go from the bottom. Let's talk about, because as you've said, conservative plaintiffs can march into court in Amarillo and get Judge Matthew Kaczmarek. They can march into court in Fort Worth and get Judge Reed O'Connor or Judge Mark Pittman. And they know that they're going to get a highly sympathetic hearing, which will tee up some wackadoo ruling for the Fifth Circuit. So let's talk about the two cases which you wrote about this week.
Yeah, so there are two cases that have been pending in, well, all over, and they were filed in Texas. The first case was filed by SpaceX and was the result of a National Labor Relations Board investigation against SpaceX, and relating to actions that did not happen in Texas, but company-wide policies would affect their Texas operations. And so they purported to have venue in Texas and brought this case challenging the constitutionality of the National Relations Board. Even though the division that was bringing the proceeding against SpaceX is located in California, the actions that they were dealing with were located in California. And the case ordinarily, the proceeding, had it gone forward, would have been in California.
Yeah, just to drill down on that, what this is rooted in is that several employees of SpaceX in, I believe it is Los Angeles, but it's definitely in California, several employees circulated an open letter criticizing Musk, and they got fired, and then they filed an employment complaint with the NLRB in California. And the NLRB set a hearing, and so they marched into Texas because SpaceX does have facilities in Texas, and they demanded a hearing in Texas. They did not get a judge whom they wanted. They got an Obama appointee named Rolando Olvera, but they were in Texas, which is where they wanted to be.
Well, yeah, I mean, where they wanted to be. I mean, so this was the first of a handful of challenges that have been brought to the NLRB that are attempting to sort of extend the SEC case that the Supreme Court is hearing this term and challenge the appointment of ALJs at the NLRB and NLRB commissioners.
That's administrative law judges.
Yeah, sorry. So they're essentially trying to undermine the entire basis of the NLRB. They effectively neutering it. And they brought that challenge in Texas. The other challenges aren't brought in Texas, but my view of that is that they don't actually mind if they lose the other ones. As long as they win this Texas one and it gets affirmed by the Fifth Circuit, or even if they lost at the district court and then it gets reversed at the Fifth Circuit, as long as they get a decision from the Fifth Circuit, they're going to create a circuit split. And that is the way of getting to the Supreme Court on this. And it's sort of forcing the Supreme Court's hand. So that's why. Now, keep in mind, this isn't Elon's plan. This isn't some big Elon plan. It's anti-labor lawyers who have joined up with him at Morgan Lewis, who are backing him on this case. This is an anti-labor plan that they're not even hiding. I was Googling around over the weekend, and ironic in light of the other case that we're going to be talking about, the U.S. Chamber has a blog post basically that pulls these cases together and says exactly what they want to do and why. This isn't hidden. This isn't a secret. They want to create a circuit split. They want to force this issue at the Supreme Court, and they want to hobble the NLRB.
And can you explain just real briefly what would happen if ALJs go away, administrative law judges go away, as they explain to us the basis, why this is going to not only be a bad for labor, but also kind of handicap the administrative state as they, would aspirationally?
Well, yeah, the SEC case is, an interesting situation. It didn't go as well for the anti-administrative state side as they might have thought it would have gone in light of this court. But the goal of this project is essentially to hamstring quick action by agencies, to force everything into courts, to not allow agencies to conduct hearings, to consider whether people have violated agency regulations that were set forth by Congress, given the agency authority to set forth those regulations by Congress. It's this attempt to end the administrative state. It's all a part of the Chevron, the reckless case that was originally Loper Bright Industries, and make it so that when Congress passes a statute and says these people that we're forming this agency to hire experts and create a body of knowledge and then figure out the best way of advancing this clear congressional goal that we have set forth, we're going to let them do it. And one of the key ways that those agencies have done that is with administrative hearings that enable the process to move more quickly than it would if you had a full court hearing that involves all of the pretrial stuff that we see in things, involves all of that sort of motion practice.
Massively expensive for everybody involved.
Expenses. Yeah. And you just have the limits of how many cases you'd be able to bring at that point, and you'd have overburdened courts. And so you have ALJs to be able to process through what are, even people who want to end ALJs would have to admit that like 95% of what ALJs do are very rote activities that there's going to be no dispute over. There are no questions about. And they essentially would just be eliminating that government efficiency.
Right. And I think that's the whole goal, is to eliminate the government efficiency. I mean, what the NLRB is contemplating here with respect to SpaceX is not a massive fine. It's like putting up, signs in the lunchroom that say discrimination is illegal and retraining your managers, right? Because, I mean, it was Musk's bad behavior. Also, the SpaceX employees said, there is not a culture of diversity at this company. And that was one of the things that they said in their letter. So, okay, what happens is they bring an administrative complaint in the NLRB, and then Musk and SpaceX, march into Brownsville. And I do say Musk because I've written a lot about this, and we've talked about it on the show, that Musk is very big on Texas right now for a whole bunch of reasons,
right.
None of which are good. So, okay, so they march into court and they get Rolando Olvera, and then what happens?
I mean, what happens is pretty simple. In ordinary time, in an ordinary situation, there is a motion to transfer venue. There is an argument made by the NLRB that this case shouldn't be here, that everything that I've already said, that the complaint was brought in California. It relates to activities in California. The NLRB division that's hearing this and would hold the proceeding is in California. There's no reason to be here. SpaceX challenges that. The Morgan Lewis lawyers challenge that. They try to keep the case in Texas, and Olvera says no, and the case is transferred, and it goes to the Central District of California. That would normally be the end of it. This happens all the time. Cases get transferred. It is not unusual. But we live in 2024. We live in this era, and they, not me, live or are operating this case in Texas. And so the lawyers for SpaceX go to the Fifth Circuit and ask for a writ of mandamus, saying that this was improperly transferred and that the case needs to be brought back. Now, interestingly, what happens is the Fifth Circuit basically tells the district court judge in Texas, tells Olvera to get the case back so that they can consider the mandamus request. They don't rule on the mandamus request, but they ask for the case back so that they can have jurisdiction to consider the mandamus request, which is an interesting admission. It's sort of like an acknowledgement that like the case is transferred. It's now in California. The California judge basically goes along with it, says, send me a request, Olvera, and I'll give it back. That happens. The case gets back so that the Fifth Circuit can consider the mandamus request. Interestingly, the panel that gets this case does reject the mandamus. And Judge Elrod dissents. It's a 2-1 decision. And again, that should have been the end of it. It should have gone back to Olvera, who then could transfer the case. That's not what happened, because in the Fifth Circuit, as is the case in most circuits, an individual judge can withhold the issuance of the mandate in a case, basically because they're considering whether they want to take it en banc. Taking a hint from that, Texas 2 days later does request an en banc rehearing. This is wild. Like,
Yeah.
let's be clear. This isn't requesting en banc after a motion for summary judgment. This isn't requesting en banc after final judgment. This is requesting that the full Fifth Circuit hear arguments over whether a case was improperly transferred before anything had happened. Like, it's such a wild request, and yet that's what's happened now. The case has been on hold. The NLRB has not been allowed to proceed because this case has been on hold. The Fifth Circuit has refused to give the mandate back to the district court. The case has not been transferred back to California, and they are considering whether to hear that's en banc. It is procedural shenanigans that have basically kept this case in limbo now for 4 months.
Yeah, I think that, they talk about the Texas two-step, which is this weird thing that you do with bankruptcy cases. I think we're going to have to come up with a fun portmanteau or something for this, whatever this is, because it's clearly getting to be a thing. And it's, as you said, it's not the only time that this has happened. So you want to talk about the CFPB case?
Yeah, the second case is the CFPB. This is a case where a rule is promulgated in DC by the CFPB, which is located in DC, to address credit card late fees. And everybody involved in it, from the Biden administration down, is located in DC. And notably, the people who are vehemently opposed to this, the U.S. Chamber of Commerce and the American Bankers Association, are also located in DC. And also the lawyers who care about this are located in DC. But a chamber of commerce that happens to be located in Texas, the Fort Worth Chamber of Commerce, appears and is the lead plaintiff in a case that is brought in the Northern District of Texas in order to challenge this credit card late fee rule. Now, the really interesting thing in my view about this is how brazen they were about this. This wasn't just brought by that Texas Chamber of Commerce. They actually brought the case. The U.S. Chamber of Commerce and the American Bankers Association are plaintiffs in the case. They're just not the first plaintiff in the case. They are literally on the case. Their lawyers are representing this case. It's so brazen forum shopping. And they're asking for this national rule to be put on hold out of this lawsuit filed in the Northern District of Texas. Now, interestingly, this case is, it is not got by either of the judges who normally we would have expected to get it. It is originally assigned to Judge Terry Means, who's a senior judge. He, that day on March 7th, says, hey, I'm a senior judge. I don't want this big case. Transfer to an active duty judge. That's normal. That happens with senior status judges. It's reassigned to Reed O'Connor. The next
Which is
day,
who they wanted, right? That's who they wanted.
Yeah. The next day, Reed O'Connor grants a motion to expedite this case. So that's on March 8th. For the next week, Reed O'Connor takes actions in this case. They're sort of rote actions. He grants pro hoc admissions motions, which he has to do because all of the lawyers are not from Texas, because this case shouldn't be in Texas. So you've got a bunch of DC lawyers who are getting pro hoc admission to practice in this case. He approves the filing of some amicus briefs in the case for the preliminary injunction motion. Then on March 14th, he says, oh, wait, in a one-sentence order, I'm recused. And so he then is removed from the case, and that's when it's assigned to Pittman. And Pittman gets it on Thursday, March 14th. I hate that we live in a world where I'm having to tell you this specific of this, but it's really important. So he gets the case on Thursday, March 14th. The next Monday, he says, hey, I've reviewed the filings, the preliminary injunction motions in this case over the weekend, and I have a question about venue. I'd like you, he literally uses the word weary in this filing in a court order. He says, I'm weary to raise this issue, but I have a question about venue. I would like briefing on this. In the alternative, if the defendants want to file a motion for transfer of venue, I will take that under advisement. The NLRB does that, and the chamber and their friends, their Texas-based friends, fight that. They also say that they want Pittman to consider their motion for a preliminary injunction first before he considers the venue. He says, no, I'm not doing that. I'm a judge. I know how I'm going to handle my cases, and I'm concerned about venue. So
can I just interrupt you? That's appropriate, right? Completely appropriate, because venue is a threshold issue.
It's not only appropriate, as we will find out later, it's what the Fifth Circuit has told judges to do. The Fifth Circuit says judges should consider venue first when they want them to. And so he denies this request to consider the preliminary injunction. And then on March 25th, the chamber and their friends filed their response to this venue briefing, this motion to transfer venue, opposing it. And then within hours of that, they file a notice of interlocutory appeal saying that they were effectively denied a ruling on their motion for preliminary injunction, and so are appealing that to the Fifth Circuit. They take that up to the Fifth Circuit. Then on March 28th, Pittman orders the transfer of venue. He says, venue is not appropriate here. It should be up in D.C. I'm sending it to D.C.
Well, and he said it in a really irate way. He said basically, like, why are you telling me how to judge? I've been a judge for a long ass time, and this is offensive, right? Obviously, I know how to manage my courtroom, and venue is a threshold issue. And I am, by the way, overwhelmed. Right
before they filed their mandamus, or before they've even filed their notice of interlocutory appeal.
Right. And he said this division is being deluged with cases, not only like, do I need to transfer it because you don't belong here, but I need to transfer it because this is a way overworked district. And that's kind of a thing that happens when you set up a sign that says, come here, conservatives, file your bullshit conservative case here because it's going to get a really positive hearing. And so like these divisions, which were already kind of all of the federal judiciary is overworked, but these divisions are going to get really overworked because every conservative in the country is going to make a beeline for them.
Yeah, so the case is transferred to district court in D.C. to Amy Berman Jackson, and then the taking a cue from the SpaceX case, the chamber and their friends file a mandamus petition at the Fifth Circuit saying that this was improperly transferred. But now they add a new wrinkle in it, and they say it was not only was it improperly transferred, but Pittman didn't have jurisdiction to order the transfer because we had already filed an interlocutory appeal because we had effectively been denied our preliminary injunction motion.
Yeah, this effective denial was so eye-rollingly stupid.
I just want to get to, yes, you're right. I just want to get to the ruling. This time, the ruling comes out the opposite. And Judge Willett and Judge Andy Oldham grant mandamus in this situation. They say that these people challenging this credit card rule were effectively denied their preliminary injunction because Judge Pittman decided to address venue first. Now, Judge Higginson dissented, and he took the high road, in my opinion. He addressed the issues very, very well and made clear that this was a bad decision. But I actually think that Judge Willett's decision, who actually of those 6 Trump appointees is the one I respect the most, and has issued some smart rulings and does seem like he actually has a brain, and isn't just a FedSoc designed AI machine.
Yeah.
I really have some problems with this ruling because it treats those dates that I went through with you from March 7th through March 25th as if this case had not been in front of 3 different judges. And it also ignores the reasoning that Pittman laid out for why he was handling this, how he was handling it, and treats it solely. He basically ignores the fact that Pittman raised this venue question essentially within 2 business days of getting the case. He got the case on Thursday, and on Monday, he raised the venue issue. Instead, the way that Willett presents it is this case was given an expedited consideration when it was initially filed, and then the court decided to address venue sua sponte and did not rule on the preliminary injunction motion as the plaintiffs in enough time for what the plaintiffs said they needed. And I think it was very misleading of Judge Willett not to properly and fairly frame the case as a new judge got this, and within 48 business hours of getting the case said, I have concerns about venue. And also by saying that he sua sponte suggested that the defendants file a motion for venue transfer, it also ignored the part of Pittman's order where he says that he wants briefing on venue. So even if the CFPB hadn't filed a motion for venue transfer, even if the CFPB hadn't been asked to do so, he had separately and independently in that order called for briefing on venue. So it was just I thought a decision from Willett that found that they had been effectively denied a preliminary injunction, but he only was able to make that finding, which was essential to his mandamus ruling, by ignoring the facts of what had actually happened in the case at the district court. And I think that's really important. I think that I don't want to use disturbing in light of all of the other things that happen in the Fifth Circuit, but I think it's a procedural irregularity and a misleading perception of the district court case for any reader of Willett's opinion.
Yeah, I'll just say it. It's bullshit. It's total bullshit.
I mean, the decision is bullshit. There was no effective denial, but the only way that you can even make the case for that, I don't even think on the grounds that Willett made it, there was effective denial. And I think Higginson makes that case very strongly in his dissent. But I think the case for effective denial is wholly undermined if you actually accurately present the facts of what had happened at the district court.
All right. So before we go, can we talk about what the Judicial Conference is doing in the past week to kind of crack down on this? Because you have this rampant forum shopping where everybody and their brother in the conservative movement is making a beeline for Texas.
Yeah, I mean, they tried to basically say that like you're a district and you need to implement rules for filing of cases that aren't going to encourage forum shopping, that are going to are going to guarantee equal splitting of cases within districts and not limited to single judge divisions like they have in the Northern District of Texas.
So just to make it clear, so what that would mean on the ground was if you marched into Fort Worth hoping to get Reed O'Connor, you'd wind up on the judicial wheel and you might get one of the other judges in that district.
Yeah, you could get any of the Northern District of Texas judges. But the Northern District of Texas got together and they were like, we decided no. Right. We like what we do.
Right, which is crazy.
And we're going to keep it.
Right, and Mitch McConnell said, yeah, definitely. Even before that happened, Mitch McConnell and Ted Cruz were like, definitely don't do that. It's just advisory, right? I mean,
yeah.
And I interpret the judicial conference as trying to claw back some of the legitimacy which has been, squandered by these judges. I mean, not just by the Supreme Court, but by the entire federal judiciary.
I mean, yes and no.
Okay.
I mean, yes, you are right on the surface, but this is sort of like when the Supreme Court issued their code of conduct. Like, okay, you had a year of legitimate reporting, public discussion of how absurd your practices are, and you then
with respect to Clarence Thomas,
the least, and Sam Alito. And then you do the least possible thing that you could imagine in order to present an idea that you're averting that. And that's essentially what happened here. And it got the headlines it wanted, just like the Code of Conduct got the headlines it wanted. But then we still have situations every week now at the Supreme Court where people aren't recusing themselves, or when they are, they're not saying why. And that's because all of the Code of Conduct was voluntary. And so none of it mattered. And this ultimately was not a statutory change, and it wasn't a congressional law that was passed. It was the judicial conduct's sort of their rules, which it turns out aren't rules, they're guidance. And so while it's true that McConnell and Cruz were saying that, what they were saying was true. And they were, I'm not quite sure I get the politics of that. I think they should have let the headlines go and then let the Northern District do what it was going to do and force some reporter to explain that they weren't following it. But by highlighting the fact that it was just guidance, they sort of did force their hand, because they then got a request from the Senate that was then responded to that said, we're not going to do this. And so we're now in the position that Congress would have to act to change it. That's unless John Roberts decides to make this his thing and he starts coming out with speeches saying things about it that tries to force the Northern District's hand, or if, I don't know, Richmond, the chief judge of the Fifth Circuit, who has apparently started to show a little bit of an independent streak, which I think is more a result of how far right the Fifth Circuit has gotten than anything that has happened to Judge Richmond. But in the absence of some quote unquote leadership from above, the only thing that could change the way that the Northern District is handling things is congressional action. And we obviously know that's not going to happen in this Congress.
Right. I mean, let's be clear. Mitch McConnell worked his entire career to engineer this very situation. They put Kaczmarek there and they put Reed O'Connor there specifically because they knew they would be single member districts, or whatever they're called. And that, 5 seconds later is when the Alliance for Hippocratic Medicine, or whatever it's called, incorporated so that they could file the mifepristone case. So they're not going to blow up this advantage. They know exactly what's going to happen here. They're teeing up all of these nationwide injunctions injunctions and hoping that the Supreme Court lets some of them through. So, yeah, I don't think that they're going to give this up. They're certainly not going to pass any laws.
Yeah, no, I mean, they're not. I mean, you only need, I mean, the thing is, like with the Fifth Circuit as it sits now, you only need 9 judges to form a majority en banc. And you've got 6 Trump appointees, and you also have 2 very conservative Reagan appointees who remain on the court. So in most, with Judge Jones and Judge Smith, and so in most situations, all that you need is one of the 4 George W. Bush appointees on the court to go along with a ruling to get a majority of the circuit. There doesn't need to be any engagement with those 5 Democratic appointees.
Right. Even if you get a panel that does a sensible thing, you just go straight to en banc, you as a conservative litigant.
Yeah. The Fifth Circuit is, I mean, the Eighth Circuit only has 1 Democratic appointee right now, which is its own horror show. And yet it's this way that the Fifth Circuit, I mean, it's the Kyle Duncan and James Ho of it all.
Right. It's a feeder system which they've set up to make this whole thing.
Is horrible.
Yeah. Well, that has been an uplifting show. I'm sure that everybody will want to come back for it. But I hope you will come back and talk to us soon about something not depressing. I mean, or depressing. Come back. Just come back.
Thank you so much for having me, Liz.
Law and Chaos Podcast is a production of Raise Ipsa Media, LLC, is intended solely as entertainment, does not constitute legal advice, and does not form an attorney-client relationship. This show is researched and written by Liz Dye and produced by Bryce Blankenagel. Law and Chaos Pod, copyright 2024, Raise Ipsa Media, LLC, all rights reserved.